Hello, good morning, good afternoon. Welcome. We'll get started in just a moment here as everyone's joining us. Hello, welcome. I'm just waiting a few more seconds here as people are joining. All right, so welcome everyone. Thank you for joining us for the 2021 UN South Asia Forum on Business and Human Rights. This is a session titled Introduction to the UNGPs and the ILO MNE Declaration. I'm Dory from Q Design, and I'll be your technical facilitator today. The chat is disabled for this session, so please send any questions for the speakers through the Q&A function. And please note that the session today is being recorded. If you have any questions about Zoom or require technical assistance, please feel free to privately message me. You'll see there TF Dory Nguyen for help using or you can actually send a message through the Q&A to me. And now I will hand over to Surya. Surya, the floor is yours.
Thank you very much, Dory, and a very good morning to, or good afternoon if you are in different part of the world, to all the participants who are joining this session. It's really wonderful for Geeta, who is from ILO, and myself, Surya, from the UN Working Group, to do this joint session for the first time. And I'm going to share my screen, and then we will start talking about UN Guiding Principles and the ILO MNE Declaration. I hope all of you can see the screen. We hope to cover these issues in today's presentation. I will briefly start with the standard setting at the international level, and then introduce the UN Guiding Principles, and then pass it on to Geeta, who will talk about the ILO MNE Declaration, and then we finish with interlinkages. And we hope that there will be some time at the end for questions and comments and some interactive dialogue during this process. So let us get going. I think this phrase, business and human rights, is relatively new. We can say it's the last 20, 30 years. But the standard setting at the international level started at least in the 1970s, early 1970s. And I would like to briefly mention how this all started the UN level, in the ILO and the OECD level. And this is something that should give you a sense of that evolution. So in 1970s, United Nations started to draft a code of conduct to regulate the conduct of transnational corporations. That process started around 1972, but it resulted in a draft code which was proposed in 1990, and you see across sign this code was never adopted. On the other hand, around the same time, ILO and OECD started looking at drafting some principles or code of conduct for multinational enterprises. They use MNE rather than the TNC for their documents. And you will see that OECD adopted these guidelines in 1976, and around the same time, the ILO adopted this declaration in 1977. So the latest version is 2017, the document that we have from ILO now at this particular point of time, and Geeta will talk about more on that. But you can see the evolution. It has gone through several revisions, but in my view, the three significant revisions, 1977 is of course the original document, and then 2000 and 2017. Similarly, the OECD guidelines have been revised, and I think there are three significant milestones: 1976, the starting point, 2000, and 2011. And 2011 is also the time, as you can see here, where the UN Guiding Principles were unanimously endorsed by the Human Rights Council. You will also see here that the UN level lot of activities have taken place in those last 50 years, but only two things have got adopted: the Global Compact of year 2000 and the UN Guiding Principles 2011. The draft norms could not be adopted, and we do not know yet how the treaty process that is started in 2014 will go. So UN Guiding Principles is the globally accepted authoritative standard when it comes to the business and human rights field. And you will see here that it is also getting aligned with other instruments. So the OECD guidelines that were revised in 2011, as well as the ILO declaration, they are. So all these three documents, I would say now, are aligned in a way, asking businesses to do certain things. I think I already mentioned to you that the UNGPs were adopted in 2011. What are UN guiding principles? I think many of you should know, but just to reinforce the point, they apply to all businesses, not merely TNCs or MNEs. They apply to all businesses, and they cover all human rights. And the word human here is used in a broad sense. So even labor rights are included, and perhaps because of the close interlinkages, even environmental rights are included. Now, there are three pillars. They're often called as protect, respect, and remedy. These three pillars should not be seen as three compartments which are watertight. Rather, they are close connections between these three pillars. And you will see on this slide that the first pillar is about state duty. So here the focus is on what should governments do to ensure that the human rights are not abused by businesses. Pillar two is imposing an independent responsibility on businesses, and again, all businesses, to respect all internationally recognized human rights. And pillar three contemplates a role for both governments and businesses, as well as other actors, in providing effective remedy. So I'm going to explain a little bit all these three pillars in a second, but before we go there, let me also try to answer a question which people often ask, that, okay, what is the legal status of UN guiding principles? Now, under international law, they are not legally binding, they are not a treaty, but they are highly persuasive and impactful. And of course, they can also become legally binding in practice for businesses because of some legislation. And in European Union, for instance, mandatory human rights due diligence is emerging as a legislation, or they could be a treaty which adopts the UN guiding principles that may be taken into account in future. On this slide, very quickly, you can see a number of either laws or policy documents in different countries all over the world that have been inspired by the UN guiding principles. And I think this is unprecedented. I think there are not many UN instruments which have made such an impact in just 10 years' time. You can see the same here on this slide, which is from the World Business Council on Sustainable Development. And I think they try to map what national action plans, legislation, policy initiatives, and other initiatives from different multi-stakeholders are in this field of business and human rights. So I think we should look at all this field in a very holistic manner rather than looking at these compartments. Now, in the same year, 2011, the UN Working Group was also established. And there are 5 members. I represent for now. And of course, the other members representing Africa, Western Europe, Eastern Europe, and Latin America. And these 5 members, collectively, we have the mandate to promote the dissemination and implementation of the UN guiding principles. I think that is a key document. How do we implement UN guiding principles? There is no one size fits all. There are many ways to implement UN guiding principles, but I think one most critical and perhaps the most dominant tool is the National Action Plan on Business and Human Rights, in short, or the acronym is NAP. Now, how should states develop national action plans? The working group has provided some guidance. And I think the starting point is that any plan to be considered a national action plan on business and human rights, it must satisfy these 4 criteria. The starting point is it should be founded on the UN guiding principles. I think this is a very simple point. But I would like to add here that it is merely the starting point, that the National Action Plan looks at UN guiding principles, but it should not be the end point. And the governments should look beyond. They should look at, for instance, the ILO standards. They should look at all the international conventions that the states have ratified when they're drafting a national action plan. So if governments merely look at the UN guiding principles and don't go beyond, perhaps they will not do a good job of drafting a national action plan. So a more holistic approach is needed. Of course, every country is different. For instance, we have a country, Qatar. Now, if you look at Qatar, the profile of Qatar is very different because most of the population of Qatar is migrant workers. On the other hand, if you look at Mongolia, many people travel in Mongolia. So there are nomadic people who are walking around in different parts of the world. So that is very different. If you look at India and China, so huge countries with population. So we cannot have the same action plan for Qatar, Mongolia, or India and China. So I think the diversity is quite relevant. Indonesia has more than 10,000 islands where people live. So we cannot really compare how Indonesia is going to grapple with business and human rights challenges with Qatar, which is a landlocked country. So I think those diversities are absolutely crucial to take into account. But what is also something to be stressed is that the process should be inclusive and transparent. Because unless there is a buy-in from all the stakeholders and everyone is on board, the progress is not going to be much. And of course, no national action plan is perfect. And that's where the regular process to review it and update it is absolutely vital. Now, we have also provided some guidance in terms of the 5-stage process, that how the government should go about it. Of course, they should make a political commitment. And I'm sure there will be other sessions where this issue is going to be discussed. But then the second stage is that each country should make an assessment and do wider consultations with different stakeholders. They should draft a document and perhaps invite comments again, and then implement it and finally update it, right? And of course, in this process, it is quite possible that they may wish to revisit the whole process again after 3 years or 4 years, because that has been the case. Now, on this slide, you will see that there are 24 countries that have adopted standalone national action plans. And you see they are in different continents. Let me put it this way. In Asia, we have 2 countries, Thailand and Japan, which have adopted national action plans. So you don't see anything from South Asia as of now. But you should be aware that Pakistan recently released the draft national action plan, and India had released the zero draft some time back. So I expect that both Pakistan and India should have a national action plan sometime this year. So I think then Asia is going to jump, hopefully, to 4 or if not more by the end of this year. So this number is going to change, of course. There are also a couple of countries which have a chapter on business and human rights. So I want to mention this on the table because some countries may prefer to start with not having a standalone national action plan, rather having a chapter on business and human rights in their plan on, let us say, human rights as such. The second point I would like to mention is that when we say standalone, we should not confuse it that we are creating a compartment of business and human rights which has no correlation with environmental rights, labor rights, or other issues. Rather, the idea is that whatever this business and human rights plan is, it has to really be cohesive. And it cannot be cohesive if it does not take into account the domestic framework or international framework about labor rights or other issues which are broadly relevant about climate change, for instance. So I think everything should be taken into account. So I hope you are understanding the background and the context. Let me now dive into the 3 pillars one by one before I pass it on to Geeta for unpacking the ILO MNE Declaration for you. Now, pillar 1 has 10 principles, and these principles are rooted in international human rights law, and they are provided some specific context and recommendations. What should governments be doing? It will not be possible for me to go into detail into each of these principles, but I think what we should do is that we should have perhaps a poll question for your consideration now. So, so the IT team, Dori, if you can launch the poll 1 question at this particular point of time, that would be excellent. So I hope all the participants can see this question before I start talking about your responses, and hopefully you can quickly vote, and then we can discuss based on your response. But in the meantime, let me keep on talking about principle one, which is basically that states must take all appropriate measures and steps to ensure that businesses within their territory and jurisdiction do not abuse human rights. And I would like to clarify the distinction between territory and jurisdiction. Territory is a word which connotes the physical territory of each and every state. But jurisdiction is a wider concept because here the jurisdiction may apply even outside the physical territory of a particular state, right? So I think there can be situations where the company from a state, let us say state is Nepal. So that company from Nepal may be operating in Bangladesh. Then the question is, should the government of Nepal has any duty to control the behavior of its company operating in Bangladesh? I think that is the question we are dealing with. So Dori, I think if you can share the result now. All right, so that is an interesting finding. So overwhelming majority of people are talking about this, that 96% of the people are saying that the governments have a duty, that they should regulate the behavior of even others, right? And I think this is quite remarkable because if you look at, sorry, I think I did something wrong here. Sorry for that. Uh, so if you look at principle two, the crucial thing is that the expectations that the government set out, they are applicable throughout the operations of businesses, which basically means that it is not enough if Indian government would like to regulate its companies operating only within its territory. The expectation is that Indian government should also regulate the Indian companies wherever they are operating anywhere in the world. And I think that is a key consideration as part of principle two. Now, of course, there are, as you know, there are some state-owned enterprises, and in South Asia, sometimes they're known as public undertakings, right? So you have some examples here from these public sector undertakings, whether it is ONGC or Pakistan Railways, or it is Ceylon Shipping Company, or we have this Bangladesh Jute Mill Corporation in Bangladesh, right? Of course, we can find multiple examples of it. So whenever we have state-owned enterprises, principle four expects a higher expectation from from governments. They should, for instance, require these businesses to do mandatory human rights due diligence because they are in a way linked to the government. And if those public or state-owned enterprises are abusing human rights, in some cases, those can also be reflected on the government. So I think you should be more proactive in ensuring that these businesses lead by example. I think that is absolutely vital. And I think working group also provided a report on that. Principle five is another principle I would like to briefly mention because everyone talks about that we have the private sector providing these public services. And I think there's nothing wrong with the private sector providing these public services. But I think the difficulty arises in those situations where the private sector is not subjected to human rights obligations. So let us say the government is providing water to everyone. Then of course, right to drinking potable water is a human right, and the government must ensure that everyone has that right. Now, if that contract is given to a private company and that private company is setting the price which is unaffordable for many, then this is going to raise significant issues. Same will apply to education, health services. In the COVID time, health is a big issue, right? So I think the key message of principle five is that whenever you are outsourcing any key government functions to the private sector, the government has an obligation to ensure that those businesses respect human rights while providing those services, right? So I think this is a key message here. Policy coherence is also a key component of UN guiding principles, including Pillar 1. And here I would like to give an example from principles 8 and 9. Let us say these are the five fingers in a hand. So you can see the government departments like this, right? So we have the Ministry of Labor, Health, Education, Mining, Environment, Education, so on and so forth. So if these ministries do not work together in a cohesive manner, then it is quite possible they may take policy actions, or they may decide to make regulations which are incohesive, inconsistent, right? So let us say the Ministry on Climate Change would like to reduce the coal or the coal industry, right? Because that is something we need to mitigate in terms of the resources. On the other hand, if we have the ministry which is promoting the investment in the country, they are inviting more coal projects. I think there is a contradiction here. There is incohesiveness, right? So if you want to invite investment, that is fine. And I think that is where the principle 9 becomes relevant. Investment is critical. All of us agree on that. There is no disagreement. But how do we attract investment that contributes to inclusive and sustainable economy? I think that should be what the government should be looking at. So let us now move on to pillar 2 because time is running out. So I would like to now move on to pillar 2. And again, I would like to pick on some key elements of pillar 2. So there are 14 principles in pillar 2. What is crucial for everyone to understand it, that the pillar 2 is not legally binding. It is a social norm. But at the same time, international human rights law is used as a reference point to define what this social norm is. This responsibility is independent. This independence is crucial because businesses can no longer say that this state X or Y is not doing it, and that's why we cannot respect human rights. They have an independent responsibility. Whatever governments are doing or not doing, they should respect human rights. At the same time, this responsibility is complementary because we don't want governments to go let off the hook, right? So it is kind of a parallel system in which the governments have to play their part and businesses have to play their part. So it's not either or for them, right? So what this responsibility to respect human rights really means in practice. Some people may think this is a negative responsibility, which is partly true because this has two components. And this first component is negative, that you don't do anything which is going to harm or cause adverse impact on human rights. But I think there is a positive element as well, which is that you need to address those adverse impacts at the same time, right? And here at this point of time, I would like to invite Dory to do the second poll, please. So Dory, if you can do the second poll, that will be appreciated. Thank you very much. So participants, the poll question is already there before you. And if you don't mind, I keep talking in the meantime as you participate in this poll. So I would like to say that principle 13 of the UN guiding principles is a crucial principle because it lays down the scope of responsibility. In what situations businesses have human rights responsibility. And the typology that you see there is a tripartite. So there are three broad situations in which that responsibility may arise. They may cause directly some adverse impact. One simple example could be a business that is discriminating against women. That is a causing adverse impact, right? Or it can contribute to the adverse impact. That could be, let us say, a bank providing a loan to a hydropower company, and that hydropower company displaces indigenous peoples, right? So the bank is not making the hydropower plant, right? But still, if the bank is providing the loan without any due diligence, then it may be regarded as contributing to those adverse impacts. And then there are situations of direct linkage, which may arise in the context of typically in supply chains where your products and services are made. And you can see that most of the products that we have at this particular point of time, they are made, in fact, by multiple companies. Most of us use smartphones. Dory, if you can share the result, if that is ready, that would be appreciated. So, okay, so you have an interesting finding as opposed to poll 1. So we have still majority of participants saying that businesses have a responsibility to supply chain, but some are saying, let us say 14% are saying that only in certain situations they have this. And of course, there is 1% saying 3% that they don't have this responsibility. So I would say this middle response is not in line with UN guiding principles. Legally speaking, you can say, technically, legally speaking, you can say, oh, supply chains are different companies, and I'm not legally accountable. But remember, pillar 2 is not a legal obligation. It is a social responsibility in that sense. It is based on social norm. But what is expected is that you are in fact responsible in all situations if there is a direct linkage, right? And the direct linkage can arise in a number of ways. In fact, I want to pose a question to anyone who is in the participant. Most of us use a smartphone, so why don't you use the Q&A box and give me the estimated number of companies that are involved in manufacturing, let us say, an iPhone. How many companies you think are
I asked
involved in
him
that? So if you can
doing this
use the
forever.
Q&A function.
It's probably, I say 50.
I think please don't use the microphone. I'll appreciate if you can use the Q&A function. Thank you very much for that. So put your numbers there. But whatever is the case, businesses are expected to take steps to ensure that the adverse impact is not there. And so I'm getting some interesting numbers, 450, 300, 200. So as I give you a couple of more minutes to reflect on that. So let me go to principle 15 for a second. What should businesses do? They should do three things. They should adopt a policy. So the policy commitment should be at the highest level. And that is explained further how they should do it in principle 16. I will not have the time to go into it, but we can take that in the question and answer if the time allows. But the most crucial thing is ongoing human rights due diligence, which is 15B, and they are explained further under principle 17 to 21. And the third thing is remediation. They should provide remedy, which is again explained under principle 22. So we expect businesses to do these three things to ensure that they respect their responsibility under pillar 2. Let me go back to the numbers, right? So the numbers that I have got is from 5 to 450. Okay, the real number is more than 600, more than 700 companies are involved. So we may not know them. Apple, of course, knows how those different parts are made. And I think that is the question. So if you have a direct linkage with those situations, then you have some level of responsibility to use your leverage to ensure that those supply chains are not violating human rights. Otherwise, why should you should be outsourcing? I mean, if you cannot control your supply chain, don't outsource, in my view. That is the very simple message. Now, if you see the human rights due diligence is a 4-step process. We can perhaps come back to it later on. But assessment is the starting point. And if you find there are some issues, let us say child labor in your supply chain, then you need to do something to fix it. You change some processes, some policies, and then you track the responses. Let us say gender discrimination, right? You cannot fix everything tomorrow, but you should have a plan, what we want to achieve in the next 6 months, 1 year, 2 year, 5 year. And then you need to communicate effectively with your stakeholders. So I think those are the crucial expectations. So let me finally turn to pillar 3, which is quite vital because here we're talking about access to effective remedy. Now it is inevitable. Whatever businesses do, some violations of human rights are inevitable. So they have a responsibility to provide remedy. Now, UN guiding principles take, again, a very holistic approach that the court-based system, of course, is one option, but we can also have state-based non-judicial grievance mechanisms. These could be national human rights institutions, or these could be ombudsperson in a particular country. These could be national contact points. And then we have non-state-based grievance mechanisms. So these could be grievance mechanisms established by a company, or it could be established by international financial institution, let us say Asian Development Bank. So if Asian Development Bank is giving a loan to any company for any particular project or even to the government, they have a responsibility to ensure that the loan does not contribute to adversely to the human rights abuses anywhere, right? Of course, whenever we're talking about non-judicial mechanism, it is crucial that the effectiveness criteria of principle 31 are taken into account. That is absolutely vital. Again, I don't have the time to go into it. We can come back to those effectiveness criteria if there is any question on that. Role of the state, again, is crucial in pillar 3, because if the judicial remedies are effective, then non-judicial remedies are likely to be effective as well, because states cannot adopt a very hands-off approach that we have non-judicial mechanisms and they can take care of it, or we can just let companies establish the grievance mechanism and that will fix everything. I think that is unrealistic expectation. Of course, Principle 29 expects businesses to do that, but again, that alone will not be sufficient. And there can be some serious violations of human rights, which cannot be addressed by these corporate level grievance mechanisms. So I think it is absolutely vital. And I think this is my last slide. And here I would like to invite Dori to put the third question. So participants, that is again a question that I have for you, that what makes remedy effective? So if the remedies are not effective, there's not much point in having those remedies, right? But what makes remedies effective? What can you think of as a remedy? Is it compensation? Is it apology? Is it imposition of some fine or penalty on the company? Or is it all of the above? So I would like to hear from you on that. Now, the working group in its report in 2017 outlined a number of variables that together make remedies effective. One thing that I would like to highlight is that there should not be any fear of victimization. What we have seen plenty of times is this, that a trade union leader makes a complaint about labor rights abuses and the company finds an excuse to fire the trade union leader. If a woman complains about sexual harassment and you fire that woman employee, this is problematic, right? So who will make a complaint then? Similarly, if the remedies are not accessible, they're very expensive, right? Or it takes 10 years or 20 years, the remedies are not really effective, right? At the same time, we should also be responsive to the diversity of rights holders. So we have children, we have migrant workers. Dori, probably you can share the result now. Thank you. So we have different rights holders and their experiences can be very different, right? So I think remedies provided by states or businesses should be responsive to those different experiences. In the COVID time in South Asia, the fate of the migrant workers has been a big issue, and I'm sure Geeta will talk more about in the context of the labor rights. But I think if we are not aware of the migrant workers' unique challenges, then I think we cannot provide them effective remedies. Now, the response that is very interesting for me. It is very interesting because all of the above is the majority, 74%. And I think that is in line with what we call the bouquet of remedies. No single remedy, whether it's compensation or fine alone, is enough. Rather, you need everything. But what I found quite surprising is that apology was not mentioned by anyone. But many victims tell us that they would like to hear a sincere public apology from the company, that we made a mistake and that's why we want to fix it. All right. With this, I think I've finished my part. Thank you very much. And I will pass it on to my colleague, Geeta Rolians from ILO. Geeta, over to you. Thank you very much.
Yes, thank you very much, Surya, for this presentation on the guiding principles. I think there was a question, but I guess, and I see a few participants also putting up their hands. So maybe just, when you put up your hands, it's to ask a question. And I think it would be best to put it via the Q&A box. And then we will look at it and I guess take the questions at the end of the presentation. So I will now move to the presentation of the MNE Declaration, and I hope you can all see my screen. So as Surya was explaining, of course, in the whole business and human rights agenda, the UN Guiding Principles is the international recognized instrument and standard when it comes to business and human rights, and it clearly has it in the title. But of course, the whole issue of respect for human rights and labor rights has been on the agenda of the international organizations for a very long time. And it is clear that when you look at the guiding principles, talking about human rights, they also include labor rights. When you look at... Yes.
Will you be able to full screen hit the slideshow
I'm sorry,
button?
didn't I? Sorry.
Yeah, there you
This
go.
way, sorry, apologies. So looking indeed at the guiding principles, there is already a direct link to the standards of the International Labour Organization, and specifically in the Pillar 2, the corporate responsibility to respect human rights. It clearly says that companies should respect at a minimum you know, the Universal Declaration of Human Rights, the two covenants, and the fundamental principles and rights at work, which are standards that have been defined within the ILO as being freedom of association, the effective right, recognition of the right to collective bargaining, elimination of forced and compulsory labor, abolition of child labor, and elimination of discrimination in respect of employment and occupation. So these are the fundamental principles and rights at work defined within the ILO that are fully incorporated in the guiding principles pillar 2 on what companies should respect. But in addition, of course, there are many other human rights that have been elaborated in a comprehensive set of international labor standards since the ILO was established in 1919. So even, of course, dealing with human rights before the adoption of the Universal Declaration of Human Rights in 1948. And so I would actually like to launch a poll now. So if the colleagues, yes. So the question here is, are labor laws and labor inspection part of the state duty to protect human rights in business operations? And while you are responding to this question, I will also continue with my presentation. So when we talk about international labor standards for governments and enterprises, you know, international labor standards are, of course, conventions at the one hand and recommendations. And what actually happens is in this full area of conventions of the ILO, every government, of course, decides to ratify international labor standards and especially the conventions. So when they basically ratify them, then of course they become part of national legislation, and within their jurisdiction, the territory, they become legally binding on enterprises. But in addition, of course, there are specific declarations of the ILO, the Fundamental Principles and Rights at Work, and the ILO MNE Declaration that have extracted principles of these international labor conventions and recommendations, and as such spell them out in the form of responsibilities and guidance for governments and for enterprises. So maybe if we can see the poll, what does it say, whether labor laws and labor inspection are part of the state duty to protect? So can we see the poll? Okay, so 100%, so that's really good. So you immediately all see the connection of labor laws and labor inspection. So that is perfect, because of course, I mean, this slide clearly says that when you ratify, of course, an ILO convention, it becomes part of national legislation that then, of course, by the government needs to be enforced for effective implementation. But of course, irrespective of whether also the government has a well-functioning labor inspection, enterprises should comply with national law, and in addition, live up to these international principles that have been formulated in a number of international instruments. Now, as Surya mentioned, indeed, the MNE Declaration is very much a living document. It was first adopted in 1977 and subsequently modified and updated. And currently we are in the 5th edition of this instrument. which in 2017 indeed was updated, taking into account the guiding principles on business and human rights, but also the Sustainable Development Goals, where the specific SDG 8 on decent work is referenced also in the ILO MNE Declaration. So you can see every time there is developments happening either within the ILO or happening outside of the ILO, the MNE Declaration takes into account the international frameworks adopted outside of the ILO, but also looking at what has been adopted as new guidance and new international labor conventions and recommendations on specific areas. So the aim of the declaration is the encourage the positive contribution which multinational enterprises can make to economic and social progress and the realization of decent work for all, and to minimize and resolve the difficulties to which their various operations may give rise. So you have this double component in the aim. And of course, looking at the interconnection with the guiding principles, as Surya was mentioning, you know, the do no harm would indeed be more in minimizing and resolving the difficulties to which their business operations may give rise. But at the same time, it is also encouraging the positive contribution that business can make to decent work for all. All of the principles are actually derived from ILO standards, be it ILO declarations, conventions, recommendations, and they are actually listed in the Annex 1 of the declaration, so that if you, as a company or as a government, want to know more, you know, about these conventions and recommendations or the principles on which that are formulated in the MNE Declaration, you can find the full list of the ILO conventions and recommendations there. And the MNE Declaration is really consistent with the roles and responsibilities that Surya just outlined in the context of the protect, respect, remedy on business and human rights and the guiding principles, because it clearly highlights the duty of the state to protect through state laws, public policies, measures and actions, including in the field of labor administration and public labor inspection, and the promotion of good practices among enterprises. And of course, how you promote good practices can be done either through legislation, to trade. I mean, there are many different ways that a government has in its toolbox in a way to promote these good practices. It also highlights the corporate responsibility, how enterprises through corporate policies and practices conducting due diligence and aligning their operations with national development priorities live up to their responsibility to contribute to decent work, and through that, obviously, to respecting human rights. And also an important, the pillar on access to remedy within the MNE Declaration, the whole chapter, I would say, on industrial relations, examination of grievances, settlement of industrial disputes, has a number of very specific recommendations in this area. The approach of the MNE Declaration is very similar to the guiding principles. The principles or recommendations are addressed to governments both of home and host countries of multinational enterprises. It's also addressed to enterprises, both multinational and national enterprises, and I will come back to that in the next slide. And it's also addressed because, of course, it is an ILO instrument and we are a tripartite organization. It is also very much addressed to the social partners, namely employers and workers' organizations. And what this instrument does is that although it differentiates between the roles and responsibilities of these different actors, it very much stimulates collaboration and consultation among these different actors, and dialogue at the different levels. So dialogue between government and social partners, which is what we would call social dialogue, within the enterprises between management and the workers, and this is of course part of industrial relations, between the government, social partners, and multinational enterprises, which is then tripartite plus dialogues, or multi-stakeholder approach, but it's really involving government, social partners, and the multinational enterprises, and then between home and host countries of multinational enterprises. And that is a very important component also of cross-border social dialogue. As I said, it is, although it's still in the title, declaration concerning multinational enterprises and social policy. Since the adoption, of course, of the guiding principles, it is clear that these responsibilities are not just for multinational enterprises, but basically for all enterprises. And so in the MNE Declaration, it clearly highlights responsibilities for multinational enterprises because their operations go across borders. And so also recognizing that they often now operate not only through their own subsidiaries, but also through relationships with other enterprises as part of their overall production process. So in addition, it's also seen that, of course, the principles that are in the MNE Declaration actually reflect good practice for all enterprises, and as such do not make a distinction between multinational and national enterprises, although it is clear that as a multinational enterprise, you also fall under the expectations of your home country, and that is precisely what we see now happening more and more, I would say. Then the recommendations for governments and enterprises are in 5 areas. So different maybe from the guiding principles, here we go far more into detail in 5 areas within social policy. There is a section on general policies, unemployment, training, conditions of work and life, and industrial relations. And I will briefly go into the main areas under each of these chapters in the MNE Declaration. We don't have the time to go into detail, and I invite you all to read the MNE Declaration. But in the section on general policies, you find principles related to respect for the rule of law. And that, of course, also means governments putting in place legislation, and then the implementation or application of this legislation through appropriate policies, as well as labor inspection and labor administration. It has principles in relation to the realization of the fundamental principles and rights at work, conduct due diligence, and there is a direct link to the UN guiding principles in that respect, alignment of corporate operations activities with national development priorities, and of course that is an important element, as I mentioned, in the context of the SDGs, and I highlighted there specifically SDG 8 on decent work and economic growth. But of course, it's not linked when you look at social policy to SDG 8, but many other SDGs that have components of decent work there. And then, of course, the promotion of good practices among enterprises and consultations between home and host countries. And as I said, there is a direct link, or even within the MNE Declaration, there's actually Article 10 that makes a direct reference to the guiding principles on business and human rights, and highlights how enterprises should carry out due diligence. Of course, highlighting that this in relation to human rights understood as a minimum, as I said, as those expressed in the International Bill of Human Rights and the principles of fundamental rights in the ILO Declaration of Fundamental Principles and Rights at Work. And in addition to this reference, it also highlights that this process should involve meaningful consultation with potentially affected groups, and other relevant stakeholders, which of course you also find in the guiding principles. But in this MNE declaration, it highlights the specific role of workers' organizations, trade unions, and that for the purpose of achieving the aim of the MNE declaration, this process of due diligence and of course consultation with trade unions should take account of the central role of freedom of association, collective bargaining, and industrial relations and social dialogue as part of the ongoing process of due diligence and consultation. So this is something quite unique that you find in the MNE declaration. And of course, when you look at due diligence processes, the very first potentially affected stakeholders are, of course, workers, where the role of industrial relations is, of course, a central element in doing the due diligence. Then in the section on employment, you have many different areas, I would say, of employment, from employment promotion, social security, which is something you do not find in any of the other international instruments, but the importance of social security, and in this regard also, of course, the informal economy and how formalization is actually a very important component also of protecting workers' rights. There are sections on elimination of forced labor, elimination of child labor, equality of opportunity and treatment, and security of employment. And this last element on security of employment is one that we saw in the context of COVID, with a lot of changes happening and disruptions, of course, in supply chains, but also a lot of businesses restructuring and closing business. How can you do this in a socially responsible way by respecting, of course, the rights of your workers? This was an area where, as ILO, we received many questions on in terms of what was actually foreseen or spelled out in these international standards. Then the section on training, and I think there again, it is what governments should be doing by putting in place national vocational skills trainings, in addition to the educational, the secondary education and so on. And really leveraging also how businesses can work together with the government. And I think in, again, the current times of digitalization, the impact of COVID, lifelong learning, this is becoming increasingly an important chapter also in the MNE declaration, and about how government and workers can and companies can work together in making sure that workers are indeed receiving lifelong learning and transferable skills, so that they are able to get good working conditions and further develop as part of the economy. Conditions of work and life deals, of course, with wages, benefits, and overall conditions of work, but also a very important chapter on occupational safety and health. And you may know currently in the ILO, there are discussions about occupational safety and health, potentially becoming another fundamental principle and rights at work. This is an area, of course, that is already spelled out in the Universal Declaration of Human Rights, also in the Covenant of Economic and Social Rights, as a fundamental human right as well. And so in there, in the MNE Declaration, we have quite an extensive set of principles regarding occupational safety and health. And then finally, the section on industrial relations, where it says that enterprises should uphold standards of industrial relations throughout their operations. It has specific principles in relation to freedom of association, the right to organize, collective bargaining, consultations, access to remedy and examination of grievances, and settlement of industrial disputes. Of course, what then states and businesses are expected to do in the context of the MNE Declaration, and of course, what is also expected under other international standards, such as the guiding principles or the OECD MNE guidelines, it's clear that when we talk about states ratifying ILO conventions, putting in place national laws, other measures, enforcement, promotion of social dialogue, promotion of good corporate practices, and willingness to engage in host country dialogues. The ILO also provides, of course, support in this regard. I mean, there is the ILO supervisory mechanism also for states that ratify ILO conventions with a committee of experts looking at how these states are then putting them in law and practice applying these international obligations. And this is combined also with technical assistance given at the level of our member states, including also through development cooperation projects. And I think there also we work closely together with the working group, with the Office of the High Commissioner for Human Rights, with UNDP in development cooperation projects where we provide, of course, support to our member states, governments in the member states on moving forward in this process of protecting labor rights and protecting human rights. But we're also working directly with businesses, supporting employers, workers' organizations, and enterprises on responsible business, including through a number of development cooperation projects, and I've listed a few there. We also operate the ILO Help Desk for Business, where companies can actually ask directly questions to the ILO, but it also has a very comprehensive website where you find lots of tools for companies, also webinars that we organize on labor standards in business operations and that are available for free for everyone to use. One of the promotional tools on the MNE Declaration, I mean, Surya already highlighted, of course, national action plans. For the ILO, there are many national action plans on very specific decent work priorities in a country, like, for example, national action plans on the elimination of child labor, on forced labor, which often are developed or adopted by government social partners following the ratification of an ILO convention, or in addressing the comments of the committee of experts. And in addition to that, the MNE Declaration also has an operational tool of national focal points on the promotion of the MNE Declaration. And in this regard, I mean, these are a number of member states that have these focal points. And I just wanted to highlight there that one of the countries, of course, of South Asia, Pakistan, has actually appointed national focal points also for the promotion of the MNE Declaration, following a lot of activities that we had and are still having in Pakistan in relation also to occupational safety and health and elimination of child labor. So this is something that I specifically wanted to highlight, but also that we have had a lot of activities in many other countries of the focus of the South Asia Forum. Maybe before jumping into the slides on the interlinkages between the UNGPs and the ILO MNE Declaration, maybe we can look, Surya, at a number of the Q&As that we have received. So maybe, Surya, I don't know if you had the time already to look at the number of the Q&A, so maybe you can
probably you can look at some questions, Geeta, that are meant for you. And in the meantime, you read those questions. I can try to answer some questions that are perhaps directed at me. Is that okay?
Yeah, that's good.
So I will start with a question posed by Mr. Som Thomas. And the question is that some businesses allow harm to occur, such as pollution, and then they remedy it as part of CSR. And all those issues. So I think my response is that CSR or corporate social responsibility should not be confused with responsible business conduct or business and human rights, because we are looking at uh, remedying or preventing the harm in the first place. So let us say if a company pollutes the river, you cannot really fix it by opening a school somewhere else. Rather, the factory that is polluting the river should try to address this pollution at source and try to minimize it at the outset, rather than thinking that, okay, by polluting the river, we make, let us say, $20,000 saving, and out of the $20,000 saving, we can spend $2,000 in giving some compensation to the farmers or someone else. I think that is an approach which is not in line with UN guiding principles. I think there was also a question from anonymous attendee about due diligence and gender guidance. Probably I will respond to that and then pass on to Geeta, because there are some questions which are directed towards her as well. So in my view, due diligence, or human rights due diligence to be more precise, is becoming an international standard all over the world. And I think we need a combination of raising awareness, building capacity, and creating incentives. Because in the global south, including in South Asia, the informal economy is quite big. And I think many of these businesses which are part of informal economy, they may not even know what UN guiding principles are. What is human rights due diligence? So I think raising awareness, building capacity, and as Geeta would remind us, formalizing those informal businesses is one part of the game in my view. But I think we also need some kind of mandatory obligations imposed by governments on businesses in terms of due diligence, so that businesses take it seriously. And I would like to add here that what is happening in European Union in terms of mandatory human rights due diligence, that will have implications for businesses operating in South Asia. In fact, there's a session in the forum on this particular issue. So I would like you to understand that there is a ripple effect. If UK is going to enact a modern slavery law, that is going to have implications outside UK. So if the Germany or the Netherlands or France or the European Union as such, they're going to enact a law, that is going to have some implications in the global south. And I very much hope that countries in the global south as well start taking some both incentives and disincentives for businesses, to encouraging them to take human rights due diligence more seriously. There was another question about gender guidance for the UN guiding principles and what challenges we are seeing in practice. I think one challenge is, of course, awareness. Lack of awareness is still there. Then the other issue is there are cultural and religious norms in many parts of the world, including in South Asia, where businesses do not really understand their transformative potential. So they are still focusing on the inclusive and diversity policy. They don't want to adopt a human rights-based approach to equality. So unless we change this mindset from the language of CSR or charity to the rights-based approach, whether these are labor rights or human rights, and here we are talking about gender equality, which is a cornerstone of our society, in my view. And I think this cultural shift in the understanding of businesses is needed. And again, I would say there is a role for governments to step in. They could, for instance, link it with tax incentives. Public procurement could be linked with it. So I think there are many things that can be done. So probably, Geeta, I will pass it on to you if you would like to answer a couple of questions, and then we can take turn. Thank you.
Yes, thank you, Surya. So I see the question also in relation to India about renaming the labor inspector as labor inspector cum facilitator. You know, there are many discussions indeed about labor inspection, and indeed we see in the ILO also the labor inspection. Of course, it has various functions, I would say, labor inspection. Of course, it is there to ensure that the law is effectively applied in company operations, and as such, it has a whole toolbox of how it can work with employers, including giving fines in certain instances, but also where we see that labor inspection is also moving towards a more collaborative approach in terms of giving the opportunity to employers to make improvements in what should happen in the workplace. So it's also a more collaborative approach that we see happening in certain. So I would say labor inspection is there not only to give fines when, of course, there is a violation of labor law, but at the same time ensuring to make progress in the issues that should be respected and improved in workplaces. And I'm sure this will also come out in several of the sessions of the forum in relation to, for example, occupational safety and health. But of course, it's not the only area that labor inspection is working in. But we see indeed there are many developments in labor inspection, and also in terms of using mobile applications and so on, there are many developments. Then there is a question about does the ILO MNE Declaration comprise soft law social expectations like the guiding principles, or are they legally binding? So the MNE Declaration, as a declaration of principles, has actually the same character as the guiding principles. But of course, as Surya also explained in the introduction, they are actually building on legally binding standards. As I explained, all of the principles in the MNE Declaration are derived from international labor standards, conventions, and recommendations. So if an ILO member state has ratified an ILO convention, then of course this is not voluntary or, just, only part of expectations of what should happen, but then they are part of national legislation. So making the distinction between hard law, soft law, how these come together is basically what is happening. So I can give you the example on child labor. This is now, child labor is, especially the worst forms of child labor, is nowhere in the world a kind of voluntary approach, because this is the ILO convention that has been universally ratified by all ILO member states. So it basically has created a level playing field across the world in terms of legislations that should be in line with this ILO convention. But of course, we see many challenges around the world in actually then this legislation being fully in line with the convention. And that is precisely where also the ILO works on with the governments in ensuring that the national law is in alignment with the international conventions. But in a way, a lot of those principles are not purely voluntary. They are actually in many countries just part of national legislation. So doing these, talking about these instruments as voluntary instruments is clearly, moving away from the developments in expressing expectations on business and on governments. So I don't know, Surya, if there's another one, are voluntary, have no legal binding. So maybe you want to also answer these ones, because there are quite a number now of them.
Thank you. So there are several questions which are about this voluntary versus binding approaches. And I think this is also somehow linked to what Geeta was just responding to. So I will continue from there. I would suggest that we should not see a clear cleavage between voluntary and binding. There is a dynamic relationship between the two, and I will suggest we need both. without binding regulations, we cannot achieve the idea of social justice and human rights. I agree with that. And states have a key role to play. We cannot just outsource everything to businesses and they can self-regulate themselves. At the same time, law is always slow and reactive and expensive. So law alone will never be enough. And I think that is where this dynamic relationship is absolutely vital. I would also like to suggest that even if we have a legislation which is legally binding on paper, it may not be binding in practice. So I think we should contrast what is binding on paper and what is binding in practice. And something which is not binding on paper may end up becoming binding in practice because everyone is following it. So our recommendations is that we should not create this sharp distinction between voluntary and binding. Rather, we need both. And the crucial thing is that states have to do what they must do, whether they are in South Asia or they are in any part of the world, which is to ensure that businesses respect all human rights and labor rights and environmental rights, and for which they can use a number of policy tools, create incentives, create sanctions. And something I would like to highlight more is the role of trade unions, in my view. Whenever we talk about supply chains, freedom of association and collective bargaining is absolutely vital. Without having these two critical components, I don't think we can ever ensure that there are no labor rights abuses or human rights abuses in supply chains. And here, businesses can go beyond the legal framework. If they think the local legal framework is not good enough, they can look at international standards of ILO and UN guiding principles. And they can encourage their workers to create trade unions which are independent, if that is possible, right? So lack of binding rules or lack of effective implementation of these binding rules should not be any excuse. And I think here civil society groups and trade unions, they must work together. One purpose of Geeta and I coming together is to break silos. So we would like trade unions and the employers and everyone to work together with civil society groups. So it's not a BHR, is a separate compartment, and we have the separate universe about labor rights. We would like all of us to work together to achieve the common goals. I think that is the message that I have. Geeta, I will pass it on to you, but I also see there is a hand raised by Hilda. So I think we should give her a chance as well to ask the question by using the microphone. I see one more hand. Oh, Hilda, can you speak now? And I don't know what question you have in mind, but.
Yeah.
I'm sorry, no, I don't have any questions. Thank you.
Okay, thank you. Thank you for clarifying that. So Geeta, do I pass it back to you now for now? Thank you.
Yes, so maybe we can go to our final slides on the interlinkages, because we've already been talking quite a lot about this between the UN Guiding Principles and the ILO MNE Declaration. I think there it's very clear, as Surya pointed out, that of course labor rights are human rights, and there is an interdependence, of course, between those areas. Of course, human rights are broader than, especially when we talk about human rights in business operations, as Surya also mentioned, you know, environmental rights and of course the rights of broader communities. But it's clear that labor rights are a central component of human rights in business operations. As I already also pointed out in my presentation, in Principle 12 of the UN Guiding Principles includes the ILO Declaration of Fundamental Principles and Rights at Work as part of the set of internationally recognized human rights that businesses should respect at a minimum. And I think this is something that is often overlooked, that when in terms of the business respect of human rights, that these words as at a minimum, the Universal Declaration, the two covenants, and then ILO Declaration of Fundamental Principles and Rights at Work to be respected in business operations, because it is really looking at a whole set of human rights. The MNE Declaration itself also includes references to the Universal Declaration of Human Rights, the International Covenants, and the UN Guiding Principles on Business and Human Rights. So there you basically have the interlinkages between the instruments. Now I need to go back to, I guess I'm still, yes, always the sharing and who has finally the presentation. Both instruments are addressed to governments, businesses, and in the case of the ILO, clearly also workers. In the guiding principles, the potentially stakeholders are wider than only workers. And social partners, as I pointed out, of course, business associations, trade unions, civil society in the context of the UN Guiding Principles. But it's clear that all of them coming together, but with, of course, distinct roles and responsibilities, but as we already pointed out, very much complementary roles and responsibilities that are needed in making progress in the area of business and human rights, or the area of business and social policy, labor rights. Both instruments also take the same approach with the state duty to protect, and this through a smart mix of measures, as was already highlighted also by Surya, this smart mix of measures, including, of course, legislation, policy, many other measures that are in the toolbox of states to protect human rights, but also promote these good practices by companies. The corporate responsibility to respect, irrespective of whether the state actually upholds its duty to protect. And I think the corporate responsibility to respect is now defined in many different international instruments, as we pointed out. And then access to remedy, whether it's state or non-state based, you find that approach in the different instruments. The UN Guiding Principles are maybe more detailed on process and on the importance of national policy coherence, where the MNE Declaration is more detailed on specific decent work priorities and labor rights, which clearly highlights the complementarity of these two global instruments. And then finally, human rights due diligence is a key process under both instruments for companies to live up to their responsibility to respect human rights, with the MNE Declaration, in addition, highlighting the need to include workers in the meaningful consultations that are part of the due diligence process, and the central role of freedom of association, collective bargaining, social dialogue, and industrial relations as part of the ongoing process of due diligence. As Surya already pointed out, national action plans on business and human rights are not developed in a vacuum, but actually should take into account the guidance provided in both of the instruments to enhance linkages with international labor standards, labor laws, labor inspection, as well as social dialogue in the business and human rights discussions. And I must say there are quite a number of existing NAPs that indeed, when they do baseline to develop NAPs, indeed look also at existing labor laws, also at ratification of ILO conventions and comments of the ILO supervisory mechanism, in then defining what the priority area should be in the NAPs moving forward. There are, of course, other NAPs that could make a lot of improvement, and I think that's also part of the technical support that is being provided by the working group, the Office of the High Commissioner, ILO, UNDP, in moving forward on the development of the NAPs, and not only, I would say, on the development, but then the implementation of the NAPs, because we also see a lot of efforts are being put into developing those NAPs. But of course, the NAP is an action plan. So then what needs to happen with the implementation of these various priorities identified in the NAPs? And then finally, for business, they of course should look at both instruments for the guidance to live up to the internationally agreed corporate responsibilities. And I think with that, we've come at the last slide of our presentation, Surya, with a number of the links that are useful for participants. And I think we still have time left, Surya, for you also to maybe go back to a number of the Q&As that we have received in the meantime. So please go ahead.
Thank you, Geeta, for finishing the PowerPoint. And as I mentioned in the Q&A, we will post later on a copy of this presentation in Scud, so people can get this information. And if it may be of useful to you, that may be relevant. Now, there was a question from Marina, and my apologies, this was the first question, and we did not somehow answer this question yet. And the question is about that the expat spouses are not allowed to work. And I think that creates this discrimination against women because they don't get economic independence and all that. I think to be honest, I never saw that issue from a BHR lens unless that question was posed. And that's why I keep reminding everyone that BHR is everything. There is almost no issue which has no connection with business and human rights. So I think this is a complex question, but I think going forward, if we want to achieve gender equality, then the migration policies may also need to change. So in some cases, what happens is that a country provides an employment visa to one person based on whatever policies of that country are. And then the employment is given to that person who is granted this visa. So it could be the male person, the female, or it need not be heterosexual as well, I mean. But then the question is that what about the dependents of that person? Are they automatically allowed to work? And I think that is not the case as far as I know in many countries, not just in the global south, but in the global north as well. But that has implications in terms of the immigration policies, the migration status and all that. And I think we can look at those issues from gender equality perspective as well, that lack of employment opportunities does not create any hardship that women, for instance, are trapped because they're moving with their spouses or their partners and they're trapped in a situation where they cannot leave, they cannot work, and their economic independence is compromised. I think that is an observation I had. Now, there was a question from Vincent, Vincent. I think probably Geeta, you can also chip in on this question, but let me start by saying that when we talk about the differentiated impact, whether this is about labor rights or human rights or any right for that matter, I think the impact on us is varied. So a child is going to be impacted differently from pollution than an adult. And even within children and adults, the element of intersectionality is very relevant. So let us say if there is online bullying which is being done, that could impact women differently from men. Even amongst women, women who are from a minority religion or women of color, they may experience the online shaming differently, right? So I think for me, the starting point for everything is to raise awareness, not only of businesses, but also the government agencies and the trade union members and everyone else, that look, we cannot adopt a monolithic approach to the rights holders. And we should, when we respond in terms of due diligence, our responsives should be sensitive, and the element of intersectionality is weaved into those particular elements. So I think with this, I'm going to pass it back to Geeta. And in fact, I would also like to say a bye to everyone because I need to teach in 5 minutes time. So my apologies in advance. I need to log off little early, but Geeta has kindly agreed to stay on. And so she will continue to answer your questions for next some minutes. Thank you, everyone. And thank you, Geeta, very much. I very much appreciate it in particular because it was very early morning for you in Geneva. So on behalf of the working group and other co-organizers, and of course, ILO is our co-organizer as well, but I really want to thank your personal commitment to wake up so early and join me in doing this presentation. Thank you very much, and bye everyone for now.
Yeah, thank you very much, Surya. You can see the sun has come out at the moment. So I started with a black window, but now at least there is some light coming in, natural light coming in. So thank you. Bye. So just continuing with the question on gender and historically marginalized groups are respected. I think this is both the responsibility, of course, from the government and from businesses themselves. And there, the whole area, I would say, of non-discrimination, how we see how the discussion on, at the one hand, making sure there is no discrimination in practice, moving towards inclusiveness and inclusive workplaces to ensure that all groups, including, of course, women and other marginalized groups, are having the same, not only rights, but also opportunities in terms of respect of their rights, but also finding decent working opportunities, is something where both governments and enterprises should carefully look at. And again, where trade unions and civil society organizations have an important role to bring out specific, I would say, challenges that are being faced by these groups to correct, at the one hand, indeed, historic situations where certain groups were marginalized or discriminated against. So you need this two-pronged approach in, first of all, correcting discrimination, and at the other hand, really looking towards more opportunities for inclusive workplaces. In many cases, of course, there is also the whole component of the informal economy, as was also already pointed out by Surya, where certain groups are overrepresented in this informal economy and have difficulties moving out of informal working conditions. And when you are working in the informal economy, of course, it's more difficult to have your rights respected in working conditions and rights respected. So I don't know whether there are any further questions that we, or that you would like to ask. As Surya indicated, we will, I mean, this session has been recorded, and we will make the PowerPoint available for participants. And unless there are any other questions, and I need to look again at the screen, but if there are no further questions, then I would like to thank you all for your active participation in this presentation, both by answering to all of the poll questions and also by posing your own questions. As Surya said, this is the first time we are doing, in the context of a regional consultation, such a joint presentation on the guiding principles and on the ILO MNE Declaration. And I think it's a good way indeed of showing that the whole business and human rights agenda is basically being guided by various instruments, combined with legislation, combined with many different efforts that are being undertaken already also by business under various instruments and through bringing together all of the different partners, governments, business, civil society, trade unions, social partners, and many other actors in moving forward on the whole business and human rights agenda. And of course, we count on your very active participation in the forum, looking at what your specific responsibility and role can be in moving forward this business and human rights agenda. And with that, I'm just checking. I see, please get your MNE Declaration network to participate in the drafting of the business treaty process. Well, as you know, I mean, in the whole treaty process, the unions are obviously very much involved in the human rights business and human rights treaty process. And the ILO has also provided technical inputs into this process, sharing experiences of legally binding standards such as ILO conventions. So on this point, I say goodbye to all of you. I would like to thank also the IT team for the wonderful making sure that everything was working well with us connecting from different parts of the world. And I wish you all a really good forum. Again, the very first time that ILO, UNDP, the Working Group, Office of the High Commissioner are really co-organizing this regional forum. So a great opportunity for all of us to connect on this very important agenda. So that's it also from my side. Have a wonderful day and a really good conference. Thank you very much.